Welcome back, guys. We are streaming tonight. We're going to stream on YouTube, and I need to get us set up. So give me a couple of seconds here, a couple of minutes, and bam. Welcome back, guys. We are live tonight. Wonder how many people are going to be stopping in. I'm going to go ahead and give myself a thumbs up because I know I'm going to do a great job. So tonight we're going to talk about one of the most popular subjects to have on my website, and it's the most popular subject of all of my YouTube videos, and it's going to be how to get the city out of your way for the Airbnbs. The Airbnb people have been going through some stuff with the cities getting up in their face and trying to regulate how many Airbnbs, how many people you can have, how many cars you can have in the driveway, all that stuff. So we're going to talk about what you need to know to understand where and how the city is coming up with their misguided control over your property. So we're going to go over those things. Let me check here. Oh, we have a new subscriber, Jessica Marie and Nikki Wise. Thank you guys for subscribing. All of you guys, please, if you haven't subscribed, subscribe to our channel so you don't miss out. Subscribe and ring that bell down below so you don't miss out when class starts, because we're going to be teaching you how to get some stuff done up in here. So my name is Coach Neighbors, for those of you who don't know me. And I'm a paralegal who don't like what attorneys have been doing to people. So I stepped up. And this program is what I came up with. I'm going to teach you how to get up in the attorneys' faces. Today, we're going to review the city's misguided and unlawful control over the Airbnbs and private property in general. We are going to talk about what the city used to gain control of your property. I have a question. Are you consenting to private property taxes? We're going to have the answer to that at the end of this presentation also. We're also going to talk about the options that you have available to get control of your property deed / title. And getting control of your property deed is the best way to stop the city's unlawful codes and statute enforcements. And one of the things that we're going to talk about is the real estate deed fraud and how that affects your property. We're going to give you some ideas on how to remedy that problem. Now, before we get really into it, I want you guys to not just take my word for it. I'm not telling you to believe me. I'm providing you a starting point for your non-conventional foreclosure defense strategies and journey. And I expect you to take the information that I'm sharing with you and research it for yourself. I'm going to point you in the direction to learn what the real estate deed fraud is and how you can use it to get control of your property deed. And you're going to learn how to use it to get the city out of your face if you own Airbnb and the city's trying to run your life. So we're going to show you how to take care of that. We're going to show you how to use their fraud to defend your Airbnb or your private property from unlawful control. And we want you to do your own research and keep it simple. Before we review the corporate structure and their illegal activity, we must understand a few things. First, we need to understand what a law is, because the attorneys are supposed to be using the law to provide jurisdiction to the court to steal your property, right? We need to review the 3 elements that are necessary for something to be considered a valid law. And we will review the statutes and who makes it and who is bound to follow the statute. We're also going to review what a code is and who makes them and who is subject to following the code. And last but not least, we're going to look at what an ordinance is and who makes them and who's subject to following them. And now that once we get that verbiage down, you'll be able to decide if you are subject to following the ordinances and codes and statutes, or are you consenting to follow? In the end of this presentation, I will show you how the city is attacking Airbnb and short-term rental properties and what you need to do about it. But before we proceed, I want to ask you guys a question. Are laws used to provide jurisdiction to the court to hear a case? We'll cover the answers to that a little bit later. And we got a couple of more things that we want to review. But before we get into all of those things, I want to take a second, 1 minute here. We want to take a second and review some of those things that we just talked about. Now, what a law is. A law is, all laws start with the Constitution. And if they're not in line with the Constitution, they're not a law that we have to follow as a state citizen. And anything that's in contrast to the Constitution is considered void. So any laws have to be in line with the Constitution. Now, this is very, very, very important. There are 3 elements necessary for something to be considered a valid law. And I'm going to share that with you. If you understand this, you will be able to use this strategy and concept to block traffic tickets, zoning coding issues, some criminal charges, the whole works, if you understand this. So the 3 elements necessary for something to be considered a valid law, and we're talking from the Constitution. The Constitution mandates that in order for something to be a valid law, each state constitution mandates this. In order for something to be a valid law, it has to have 3 elements. It has to have a title, it has to have enacting clause, and it has to have a body. Now, the enacting clause is, like, to me, is the most important element, because that tells everyone from which authority the law came from and who's subject to following it. And the title and the body are pretty simple. And the law states that these elements must be with the law. You shouldn't have to go look at another book to find these elements. So if the law does not have an enacting clause, does not have a title, and does not have a body, it's not considered a valid law. Keep that in mind. Now, we're going to review what a statute is, and I'm going to share my screen, maybe. Yeah, we've been practicing, so we got it. Okay, so a statute. This is what it says about a statute. A statute is a formal written enactment of legislative authority that governs the legal entities of a city, state, or country by way of consent. So let's read that again. A statute is a formal written enactment of legislative authority that governs the legal entities of a city, state, or county, and by consent. Typically, statutes command or prohibit something or declare policies. Statutes are rules made by legislative bodies. They are distinguished from case law or precedents, which is decided by courts, and regulations issued by government agencies. So that's what a statute is. And I don't know if you guys can start figuring this out right now. It doesn't say anything about the 3 elements that are necessary to make this statute a valid law. It's just a statute, and it's a bunch of numbers, pretty much. So let's just move on to the next one, the code. Let's see what it says about the codes. Okay, a city code is a set of rules and standards of behavior for businesses that are buying other businesses to follow. The city code includes standards of fairness to shareholders and elderly framework for takeovers. So this talks about, just codes are for other businesses. That's interesting. So the statute is a legislature authority that governs the legal entities of a city, state, or county. It doesn't say anything about the people. That's interesting. So that's where the code is. We're back to rules. And let's take a look at an ordinance. A city ordinance, an authoritative order or decree. Sometimes confused with it. So this is a piece of legislature enacted by a municipal authority. Enacted by a municipal authority. Interesting. And I say this is interesting because municipal authority. So in municipal court gets its jurisdiction from the city ordinance, not from the legislature or from the Constitution. Has anyone wondered why municipal court is separate from state court? The traffic ticket court and all that stuff is down the street. The code enforcement, zoning, and all that stuff is handled down the street in municipal court. I wonder why that stuff's not in state court. Oh wait, municipal court gets its judicial authority from the city ordinance. So basically, it's an administrative authority and it doesn't have any judicial jurisdiction. Yeah, and also in municipal court, if you get a speeding ticket or any kind of a traffic ticket, and that ticket is signed by the police officer, that summons, because that ticket is a summons to appear, that is a violation of the separation clause in the Constitution, because that should be signed by an officer of the court in the judicial branch and not the executive branch, which is the branch of the people enforcing the laws. The separation clause in the Constitution mandates that those are separated. And no, they're not. And you can tell when there's a problem, because when they're not separated, whenever you run into a situation where things have been changed to speed up the process and get more people through court, you're getting hosed. So now that we know that statutes are written for legal entities of the city and they're by consent, let's take a look at a statute. So the statute for foreclosing on someone's property, is that the same kind of statute they're talking about here? Are you consenting to have your property foreclosed on? Think about it. Now, what we're doing here is we're showing that what we're doing here is we're showing that the codes, statutes, ordinances, all of those are not valid laws. They do not have the elements necessary as per the Constitution of each state. They do not have the 3 elements necessary to be considered a valid law. And that is the way people should be attacking the foreclosure situation. That is the way people should be attacking anytime the city is stepping out of their bounds, telling you what to do on your property. That is how you should be attacking it. Now, we call it eliminate property tax because I don't know how many of you realize that the property tax, the zoning, code enforcement, all that starts with your property deed being registered in their office. And most people are tricked and not provided full disclosure when it's time to do that. So one of the other things we want to take a look at is the Constitution and property taxes. So hang on one second, let me pull that up. So the Constitution and property taxes. Now this page is taken from the Eliminated Property Tax Lawsuit document, and I took it out just so you can see here. The Constitution and taxes. And this is what it says. Indirect tax are prohibited not once but twice. The indirect taxes, taxes on something which you already owned. And there can be no direct taxes under any circumstances short of a state of war. And then only if taxes are apportioned among the Union states. And I'll probably copy and paste this in the comment section down below so that everyone can have access to it. And this pretty much outlines the situation with the illegal property tax. Now I'm going to complete my my presentation, and then I'll check the chat window and see if you guys have questions and stuff. It's easier for me to do that than to go back and forth, because then I'll be skipping stuff. And then things won't make sense. And then people will think I'm more crazy than I actually am. So that's how we're going to do it tonight. So when something becomes a law, it has to be enacted. And that's according to the state constitution. Now, for the state of Kansas, this is what the enacting clause looks like. And this is what should be with every law. Under Article 2, Section 20, acting clause of bills, laws enacted only by bill. The enacting clause of all bills shall be it enacted by the legislature of the state of Kansas. No law shall be enacted except by bill. Now, these codes and statutes are not enacted by bill. The ordinances are not enacted by bill. And even though one of the definitions refers to it being enacted, it's not. And people need to remember when they're reading this stuff, they're reading stuff that's been posted on there by bar members. So, and their job is to deceive people, is what they've been doing for 150 years. So. Now, what the city has been doing, what the cities have been doing to get around the issue of violating the Constitution, well, they're still violating it, but what they've been doing to try and make it appear they're not violating it is, once they trick you into allowing them to register your deed, your property deed is reclassified to one of their commercial classifications, which is commercial, agricultural, or residential. And people don't realize that residential actually means the property that a government official lives in. So once your property is reclassified, it allows them to start the property tax problems and zoning, coding issues, and harassment. Now that we understand the registration of your property in their office is what triggers the city's unlawful control and code enforcement, we must ask ourselves, is there a law forcing homeowners to register the deed to their property in the county recorder's office? Or is the registration of the deed consensual? Now, remember, the statute that they're using to foreclose with is in violation of the Constitution, because it does not have the necessary elements to be considered a valid law. That is the best defense you can use if you're facing foreclosure. I'm giving it to you free tonight. just like I do every night. So the city's unlawful control over your private property starts out when they trick you into registering the deed and title to your property for the sole purpose of taxation. My Eliminate Property Tax Lawsuit package can help you get control of your property deed / title situation today. Getting control of your property deed is the best way to stop the city's code enforcement and harassment. If you have Airbnb, taking this process and sticking it in the city's face is the best way to protect your property. It's really sad because Airbnb and RBO and all those other companies that do this pay these cities a ton of money for taxes and all this stuff. But here's the city still sticking their hand out, trying to get in your wallet and getting, not only they're trying to get you shut down. Basically what they're doing is trying to make it so only the people who live in the houses can do this. And that would be the bed and breakfast people. So, and the hotel people are pushing for this too. And that's one of the reasons why they're doing all of these things, trying to run the Airbnb people out the door and out of business. And the city don't realize that some of these families that are doing Airbnbs are using that money to pay their bills and to take care of their families. So most of these people aren't just going to go pack up and go sit down because the city's in their face when the city does not have any legal justification to be up in their face. So once you remove your property information from their office, then they won't be able to be sending you stuff and be harassing you and making your life miserable. Now that you understand the difference between a valid law and corporation rules, you can see that you're consenting to property tax by your failure to object. You're consenting to them harassing your Airbnb by your failure to object. Now you understand the statutes, codes are not valid laws. They are rules from the corporation for the corporation. Now, the title of my Eliminate Property Tax Lawsuit package is $5.5 million claim, civil complaint for violation of the Constitution, violation of 18 U.S.C. Section 241 and 18 U.S.C. Section 242, deprivation of rights under the color of law, conspiracy against rights, racketeering, and violation of the IRS code. So you can see that my lawsuit for this issue is serious. So if you're ready to challenge the city to eliminate your property tax collection, make your investment in the property tax lawsuit package, and let's get started. This lawsuit package contains a notice of claim letter that you can use to formally request that they return your deed and title. This way you can ask before you pay to file in federal court. You never know. And then if they ignore you or act stupid, then you can follow up with your lawsuit. Now, I only have a few documents in this package because it is new, and I'll be working closely with people who invest in this package to see how the attorneys try to skate the issue here. I don't see how they can when there's no law that mandates. There is no law that mandates that you have to register your deed in their office. So if there's no law that mandates you have to register your deed in their office, all you need to do is just formally request to have it back, to have them return it to you. because they didn't give you full disclosure when they took it and put it in their office. They didn't tell you that having that deed in their office was going to initiate the property tax, the zoning, coding enforcement, and all this other mess that you've been putting up with. They didn't tell you any of that. How long have you been paying property taxes? How many years have you been paying property taxes? Right. And so that's where we're at now. If your property deed was removed from the city's records, your property deed and your title, they would not be able to include your address in their harassment, extortion campaigns against your property. And one of the other things that people don't realize either is that back in the old days, we didn't have to register the deed to your property in the county recorder's office. It was, you'd go down and you would have it notarized and you would keep it in your Bible. And that's what everybody did. If someone wanted to try and take your property, they would have to come up with a deed that was registered prior to the date of your registration. It was simple back then. But now they have it complicated, and we have to file a deed in their office for all these reasons, because the chain of title and all this stuff. At the end of the day, having your deed in their office is a liability, and I'll explain to you why. In my private Facebook group, I have several members in that page who have paid off their deed. They have the lien release, the deed. They have everything to show that their property is paid off in full, but yet they're in foreclosure. Well, how in the hell does that happen? Well, it happens because these attorneys go to the county recorder's office and they get your property information from the records, and they file that information in a fake assignment, a fraudulent assignment, and they file that assignment against your property as a foreclosure. And they know the odds are in their favor because 80% of Americans can't afford an attorney. And 56, probably higher now, percent of Americans live one emergency away from struggling. So, and if you're in a non-judicial state, they know that you only have a few weeks to figure something out. And if you don't, they're selling your house on a freaking auction. End of the story. And then once that happens, you have a few more weeks before they serve you the unlawful detainer and start the process to kick your butt and your family out on the street. So they know that they have the odds in their favor. And that's why they do it. It's sad. They attack people's property. And I have people call me and they're probably being attacked and they never missed a payment. Some greedy stuff going on. So that's it for my presentation. Now I'm going to see if I can find that chat window so I can talk to some people and see what you guys got to say about this mess. Okay, hey everybody. On Deuce, I got some new people. Ooh, bankruptcy. Well, on Deuce, I don't do bankruptcy because I think it's a total waste of your time. You're better off because the bankruptcy is run by attorneys. Anytime you have attorneys involved in your program, you're going to get hosed. Hey, Joy. So really, we got stuck on this property tax thing because we had several people in our private Facebook group that were facing property tax lien foreclosures. And so we got started on this property tax thing. And man, for the more we went down the hole, the more interesting it became. And now, yeah, so I put this package together. And I'll tell you, I get a lot of blowback from it. People think, oh, you're trying to escape the system. Oh. I'm like, the Constitution shows that it's illegal for what they're doing. So how am I escaping the system? These people have been escaping the system for years and throwing people out of their house because of the illegal stuff. Joy says he's getting ready to file his non-judicial lawsuit this week. Good deal, Joy. Just make sure that you don't give her all the documents at one time. Give her them one at a time. Are you going to file the restraining order as well? Are you in the eviction? I see you're in non-judicial. Are you in the eviction process? Yes, on Deuce, the system is fraud. Joy says he can't wait. Now, you guys need to, I'm going to post that video in here. You need to watch that. Make sure you watch the video if you're in the non-judicial. So once you get your lawsuit filed, especially if you're facing the eviction process, once you get your lawsuit filed, then you can immediately challenge the eviction court jurisdiction and use your notice of removal to remove it right out of that court and you out of state court to be connected with your case in federal court. You don't want to give the state court judge time to respond to it. So you don't want to do that. You want to stick it in his face and then move it. It's the instructional video for the non-judicial foreclosure lawsuit package. So Joy says he's been kind of hanging under the HUD moratorium. Is up on the 31st. Well, dude, you really should get your stuff filed like long before now, if you can, because if you wait, you know, you're going to be in the group of all the people that are going to be stuck in line waiting for the people that already have their stuff filed in court. And they're going to be trying to throw you under the bus and not give you a chance to get in court. I think that's what's going to happen to a lot of people. Put a lot of work in this program, and I love my job teaching people how to defend their property and get up in these attorneys' faces. So the other day I was going to show you guys my new online course, and I couldn't because I didn't figure out how to share the window, but I figured out how to share the window now. So I'm going to show you my course today. I'm going to take you behind the scenes here in 1 second. Okay. This is my online course, my paralegal school. Got 1 student enrolled. Yay. So this is the sales page. This is the sales page. And, oops. So I'll leave that there so you guys can read it if you want to. Thanks for sharing. And this is what the curriculum looks like in the online course. First one, the first lectures, you know, how to use the course outline. Then we have a welcome video. So this course is structured with videos and lectures and pictures. And I'd like to have a couple of Zoom meetings at some point when I get enough people in it to make it valuable. We can have a meeting and we can discuss in the meeting the different obstacles that people are facing or whatever, and or if there's any changes or anything. And if you guys get in the course, please leave me comments in the comment section down below, and also leave me a review so people can see that the course is real and it's badass. So these are some of the other things, the resources. Let's click on that and take a look at the resources. I think I'm going to have to, oops, I'm not logged in. Okay, let's log in as a user. Logged in user. And then we're going to go down and take a look at the resources. So this is the first resource, and this is one badass document here, the Top Secret Banker's Manual. And we've taken some of our strategies right out of here and put in on the paper. In this course, I'm going to help you guys learn how to structure your own documents. It's not really, okay, so one guy said, okay, I love the way you think outside the box. No, there's no box the way I roll. The way we do things, there's no box. So you have to like not go in my program with these blinders and limitations that you were taught from attorneys. And this top secret banker's manual is absolutely the bomb. And let's see what's. And here are just a few of the other documents in here. You have the new motion for reconsideration. And this is the document, the magistrate judge reconsideration. This is the document that you will be using if when the magistrate judge dismisses your case without your consent. People don't realize that the magistrate judge does not have consent to be involved in, does not have a jurisdiction to be involved in your case without all the consent from all parties. So in this package, if the magistrate judge dismisses your claim and doesn't even allow the other side to answer to it, because that's usually what happens, then this package is what you need. You have your motion for reconsideration, which is pretty much your objection to the judge's order. You have your motion to recuse the judge for allowing attorneys an unfair advantage. And the interesting thing about recusing the judge is all you have to do is show the appearance of impartiality. And that's real easy to do when they get done violating you. And we also have in there your claim, your notice of claim against the judge for violating you. And that notice of claim is actually the claim. So you just take the notice out and you can file it as a claim if you need to. So what you're going to learn how to do in this course is you're going to learn how to hold the people that are blocking you from having your day in court. You're going to learn how to add them to your lawsuit and force them to visualize your shared liability. So at the end of the day, it don't matter who you're suing. If you're suing the judge, if you're suing the attorney, if you're suing the clerk, whoever's blocking you from getting in court, that's whose butt you need to have on your paperwork, because that's the way this goes. If you don't address the misconduct, you will never have a chance to make them stand down. And that's the difference between what we do. 2, 1, we're going to show you how to address the misconduct. And I don't care if it's the judge. We're going to show you how to address his or her misconduct. And 2, we're going to help you learn how to do it yourself. I tell people all the time, you don't need an attorney. You don't need to pay someone to help to mess up your case. You can mess up your case all by yourself. That's actually what I tell people. James Galley said, I give actionable advice. Thank you, James. And that's what this YouTube channel is all about. I give you the advice you need. If you have experience at putting what I say on the paper and being able to use it to help you in court, there you go. If you need help, we have the documents available. We have the lawsuit packages on our website, and you'll get there, like in the non-judicial package, I think it's 16 documents. And the documents that's in the lawsuit packages are different than what I have in the online course. The online course is more badass, I'm just telling you. But the document in the lawsuit package, I've been doing the job. I just had to step up and add more value in the online course because it's my premium package. And that course is set up so you will be using the jurisdictional challenge with an affidavit to blow up the state case in their face before you file your lawsuit in federal court. They can't respond to a jurisdiction with an affidavit. They can't respond to my jurisdiction, period. And you will be able to use that as evidence, as an exhibit and evidence in your lawsuit in federal court that you made them go sit down in state court and they couldn't answer. And if you're going into federal court with this documents from state court showing that state court didn't have jurisdiction to hear the case, that's a problem for them. And it's it's a benefit for you because now you can just tell a state court, hey, they already didn't have jurisdiction to hear the case in the lower court, and that's why I'm going after them. They're collecting as a third-party debt collector, and they have no witness to give the court jurisdiction, so they messed up bad. And I know federal court don't want to go through the hassle of having hearings and having a trial and all that when they messed up at the gate. And the statute that they're using for the foreclosure does not contain the necessary elements needed to be a valid law. Oh yeah, you see here the inventory notice of recusal of the judge, the motion to object. So the lawsuit packages I actually put on the pages that cover that situation, so you wouldn't have to flip back and forth, back and forth, back and forth. So there are more resources than just these three. I had to put them on a couple of pages to still learn how to put this, how to operate this software. So let's look at one more thing. About the instructor. We're going to look at about the instructor and see what the hell's going on with the instructor. Bam! I love this. And I left this really huge on the page. Dream big and make it happen. Yeah, I love that. Dream big and make it happen. So many people sit around and want to know how many have you won? How many? I'm like, dude, if that's your question, you need to come back because you're not ready. At the end of the day, people need to understand, does the process make sense? If it makes sense, then you need to be thinking about doing it. You're gonna sit around waiting to see how many people win. Well, it's not about winning anyway, because that's the way you look at the situation in the conventional program. In a non-conventional program, in the conventional program, to win means the judge is gonna give you something. Well, you already know that ain't never gonna happen. Okay, so there's no win. What you need to do is you need to make the attorney go sit the hell down. And that's what we're working on. And I'll leave this up and let you guys read that for a second if you want to while I look at, yep, I know I'm not a 14th Amendment citizen. And there's a picture of me. So let's get back. And I'm going to log out as a logged out user so we can see the rest of the curriculum. Okay. So you can see here the rest of the curriculum, or the banker's ultimate fears. That's something that you must read. And this actually came from the PDF, the Banker's Secret Manual. I just kind of outlined it and put it in here just on the page because it's 246 pages and most people aren't going to go through the whole thing and you might miss this. So I copy and paste this in its own page because it was very special. Tips and strategies. So when you guys are using my my YouTube channel, you need to remember a couple of things if you're trying to find videos on there. So the videos on my channel are listed in playlists. So we have playlists for tips and strategies, the playlist for judicial foreclosure, non-judicial foreclosure. So we got a playlist for everything. Now the title of the video, the title of the videos, the first part of the title is just what I use to make my video rank. The second part of the title is actually what the video is about. So I have a lot of people like the first part of the title might be stop judicial foreclosures in Georgia. And then people who live in another state are wondering if that, yeah, it works the same. What you need to look at is the second part of the title. That tells you what the video is about. The first part of the title is just the words that I need to have so YouTube will show my video. I have to pick a title because my channel is small. I have to pick a title that I can use to get my video in the top 10 or the top 5. It would be perfect, but I'll settle for the top 10. So the first part of the title might be a little weird or might not seem like it applies. The second part of the title is what you need to look at, because that tells you more about what the video is actually about. And conventional versus non-conventional, and that is one, you have to understand that to be able to follow along with what we're doing. Because if you don't, then you will be looking at everything from the conventional perspective instead of the non-conventional perspective, and then you're going to get yourself all twisted up, and then your anxiety is going to take over, and then you're going to be, you don't want to do that. You want to leave them separate. You can't mix the conventional with the non-conventional, because the conventional is stinky, and if you mix it with the non-conventional, it's going to make the non-conventional stinky too. And my stuff is designed to block the arguing, okay? But we already know that their program is structured to argue, and when the arguing is over, then the judge gets to help them, and that's just the way they do things. So we want to go in with things that they don't want to argue about. So conventional versus non-conventional. In the conventional program, they offer 3 options: loan modification, short sale, and bankruptcy. Oh wait, there's a 4th option: move out. That's the option that they throw on the table when they're done sucking the money out of your account. In the non-conventional, you're holding them accountable for the misconduct that they're doing. That's the difference in a nutshell. And the Rooker-Feldman doctrine, yeah, I answered that. That's ridiculous that they use that. And people get so freaked out about the judge's order, they don't even spend time reading or looking up the doctrine or anything. If they did, they'd find out that the Rooker-Feldman doctrine does not apply. It applies to plaintiffs from state court, not defendants. And if it did apply to the defendants from state court, that would mean that you have no rights, and they can foreclose on your house and you can't do anything, which is ridiculous. But people believe that because they believe the nonsense when the judge, posts that stuff. People think the judges know. The judge is not going to be fair with you. The judge is a bar member, and the judge's job is to help them, not you. And so then we got a section here, things you need to know. And then we get to the documents that you must file. And then we have the documents all outlined. Now, Joy had a question, when am I going to get the non-judicial? That's next on the list, Joy. And it's not going to take me near as long to do that one as it did as it took me to put this together, because doing this one, I had to learn how to use software. You're working on the back half to put it together to make it look cool on the front half. And if you have no idea what the hell you're doing, it doesn't look cool on the front half. So it took me a while just to learn how to run the software. But when I'm ready to do this, I'll be able to duplicate this whole course and then change the things in, because there's not a lot of things that need to be changed to make this fit for the non-judicial. Not a lot. And most of the concepts are all the same, and the strategies are the same, but there's just a few things that need to be changed, because in the non-judicial, it started by the default letter that's signed by the attorney, as opposed to in a judicial foreclosure, it's the petition that's signed by attorney. So there's a little bit of difference there. So you can see here all the documents that we have here. And these documents, the titles of them are the same. And some of them are the sanction. Well, no, the sanction motion has been changed too. Some of the documents are the same, but the main ones have been changed to add a little more juice to the program. And then this little thing here, I added something to it after I was all done. Oh, I need to go down here, sorry. So what I did was I added legal malpractice and breach of contract lawsuit. And I added that in. So if you had an attorney that was throwing you under the bus, once you get your situation under control, because you don't want to waste your time doing this until you get the situation under control. And once you get the situation under control, you can go after the attorney for legal malpractice and breach of contract. Now, you have to remember that attorneys are the ones that structured the program that we have right now. And it's not structured to be fair for us. And in legal malpractice, it's absolutely difficult to prove damages unless a bunch of people die. So what we've done is we structured this lawsuit to go after them for breach of contract to get your attorney fees back. So it's not the same as suing for the $5.5 million, but it's a punch in their face. And possibly they will pay you because they don't want to have all this in their face and post it on their reviews and all that. So that's and you know, this you can use to recoup the money that you pay for the course. And then there's a little bit about Coach Neighbors. This course is closed for enrollment. I think I need to change that because we're open now. And these are some of the people from our private Facebook group that have been using my documents and strategies. And Shamel Maxwell here, she used a jurisdictional challenge with an affidavit to stop the sale of her dad's house. And she also reopened the default judgment. And once she reopened the default judgment, she went ahead and filed her lawsuit in federal court and moved everything over to federal court. So we have a provision in our we have a strategy in our program to block the eviction process, and it works very well. And Shamel left me these reviews are from my Google page. These are Google reviews from my page. And Shamel and this is Sue and Jay Boyer. They got into my program when I first started doing the lawsuit packages, which I believe was like last October or maybe September. And they're still in their house fighting. And the last I heard about 4 or 5 weeks ago was that the judge retired. The second attorneys the first attorneys quit. The second attorneys that took over have not answered to the jurisdiction challenge or any of the last documents that they filed. And she's in the process of filing for default judgment. And Joyce, she just started. She was in on our feed here day before yesterday, on our live stream day for yesterday. And so she just started with hers. Like you can see, she got her stuff 3 months ago, and she left a real nice review. So, you know, everyone says, oh, you're crazy, you can't do nothing, you can't fight the bank, you know, blah, blah. Well, you're not fighting the bank. People don't realize the bank is not the one that's foreclosing. When you get to foreclosure, The bank has already written that stuff off their taxes and claimed it on the insurance. You're fighting the attorneys out operating as third-party debt collectors. And in my program, I teach you how to attack those attorneys. You add that attorney to your lawsuit as the number one defendant, and their law firm as the second defendant, and the last servicer. Just those three people. We don't add all those other people on there because all that does is make everything complicated. And those other people already made their money. So it's got nothing to do with them. You want the three people. You want to force the attorney to have to protect his source. It's kind of like a drug deal or something, right? Want to make the attorney have to protect the source. And the problem that the attorney is going to have when you add the attorney as the number one defendant to the lawsuit is the attorney won't be able to, the attorney can't litigate a case they're a party to. They can't represent themselves. And most people don't know this, but a corporation can't represent itself in court. It's considered pro se representation. And since a corporation is considered a fictitious entity, it cannot represent itself. So the attorney has to hire outside attorneys to come in and help them. And that becomes a problem when the outside attorney finds out that you are suing the foreclosure attorney for illegally foreclosing on you, acting as a third-party debt collector. And most attorneys ain't going to touch that because they are doing the same crap. So now the judge is going to have to allow them to go through and represent themselves, and yeah, because the judge is trying to make sure that he gets paid or she gets paid or gets her free house or whatever it is they do. They do for these judges for throwing people under the bus. So that's a problem. You're welcome, Joy, for the hard work and dedication. So I've been through what you guys are facing, and I know what it feels like to see the fear in my wife's face every night when she's going to bed, or when in the morning worrying about the police are going to come and throw our stuff out on the. I know what you've been through. And unfortunately, I wasn't able to save my family, but they treated me like I was stupid and pissed me off. So here I am, years later, helping other people all over the United States. And this is my therapy. Kicking attorneys' butts is my therapy. So that's going to be it for tonight. And I'll be back on here probably on Friday. On Saturday and Monday are going to be my scheduled days that I do a live stream. That way you guys can plan in your schedule. And if there's something particular that you would like to hear me talk about, please leave me a message in the comment section down below. But make sure it's about the non-conventional attack, okay? Because I don't spend much time talking about all of the things that happened to you and all of the stuff from 15 years ago. You never want to go into court arguing the banking side of things, in foreclosure court arguing the banking side of things. You never want to do that because you will be held. And the only thing that you want to stick with is the issue of the lack of jurisdiction, because that you can stick all in their face. And I'm going to show you guys one more thing before I take off. Let me close this up and open this up, because I love this. So, jurisdictional defects and void judgments. And I'll probably copy and paste this and leave this in the comment section down below too, because this has value. So you can just read this here. I'm not going to spend a lot of time reading it. But what I want to show you is, as you can see, what's highlighted in yellow are the most common jurisdictional defects. And sometimes in some cases, there are several of these jurisdictional defects in one case. So look at these and then leave me a comment or leave me a post how many of these are in your foreclosure. So a defective petition, all the petitions are defective because there's no witness. Fraud committed in a procurement of jurisdiction, that pretty much fits in everybody's case. Fraud on the court, yep, pretty much fits in everybody's case. The judge does not follow statutory procedures. Has anyone ever had that happen to them? A violation of due process, yep. Of course, in civil court, you want to say they're obstructing the administration of justice. And that's really important. If you say it that way, they'll know that you've been talking to somebody on your legal team. If the court exceeds statutory jurisdiction, yeah, we did that one. Any acts or violations of 11 U.S.C. section 362. There's no justifiable issue presented to the court through proper pleadings. This is one that's in every case because the proper pleading would have to be, they would have to have a witness, and they have no witness. So, and they don't have the original contract, and they don't have a contract signed by the parties, just one party. And the complaint states no cognizable cause of action against the party. So probably 4 or 5 of these, maybe more, would be in most people's case. And each one of these would be grounds to have the case dismissed. Matter of fact, it is me, I would file a motion to dismiss if you're in the online course, you don't have to worry about it because that jurisdictional challenge is going to blow it all up anyway. But if you're using the documents and, you might want to, you could file a motion to dismiss with each based off of just one of these. You don't need to have them all listed, one at a time. And you could have 10 motions to dismiss. Yeah, that's the way we do it. You got to change your strategy and look at this different. You have to cost them money and time. And you have to be willing to do whatever it takes. If you're not willing to do whatever it takes, this is not the program you need to be in. And if you have fear about doing this or fear or whatever, this is not the program. I don't work with everybody. And I don't like to work with people who have fear or anxiety. I don't like to work with people who wait till the last minute and do things, because when you call me at the last minute and you've had 2 or 3 weeks to do something and you call me at the last minute, I don't even want to hear it, because that's not the way I roll. I don't jump through hoops. I tell people, my job is not to make it easy for you, okay? My job is to help you learn. And sometimes you got to learn the hard way. I had a lady tell me one day, I wish you were my neighbor. And I said, no, you don't. She said, yeah, I do. I wish you were my neighbor. And she thinks she wishes I was your neighbor because I was giving her a bunch of free information. I'm like, no, you don't wish I was your neighbor. So, well, why would I not want you to be my neighbor? Because you're taking too long to get your stuff filed. And I'm gonna blow the whistle in your face and send you to the bench. Yeah, that's what I told her. You're probably glad I'm not your neighbor. Of course, she still said she wishes I was her neighbor. I think she's crazier than me. Oh, here's one other one too. When the rules of circuit court are not complied with. When the rules are not complied with. What? So how many of those did you guys see? So Ed, hey Ed. See, you got your document already? Oh, thank you, Ed. He says he's going through my documents and I'm amazed at your documents. Thank you. You're welcome, buddy. Just remember, one at a time. You only have to do one at a time. I think in the judicial foreclosure package, I think I have 13 documents, 13 or 14. And the non-judicial, I think there's like 16. So people open that up and see all them documents. Oh, easy, easy. You only have to do one at a time. One at a time. And I tell people who are freaking out too, one step at a time. You only have to do one step at a time. And then when people remember that, it makes things a little more manageable, because you only one step at a time. The first two documents that people will be filing will be the $5.5 million lawsuit for wrongful foreclosure / breach of contract. And the second document maybe will be the restraining order. And that depends on your situation. The courts won't hear the restraining order unless you can verify that you're about to be injured or you're being injured. So if you're facing the eviction process or whatever, then that would be a good time to use the restraining order. But if you're not facing the eviction process, you'd want to file just a lawsuit package. And then the other documents, it'll depend on how they respond to them. And the instructional video has an outline and some tips and stuff that you need to understand for filing all of the documents. So you need to keep that in mind. So thank you guys. I am going to get out of here, and I will see you guys on Friday. Yeah, Saturday and Sunday, but I'm going to try to be on Friday nights too. So this late thing is kind of the best for me, because I'm done running around getting everything done, and the phone calls have died down, and so then I can actually talk and do things. Okay, I will see you guys in the next stream. Good night, guys. Oh, I forgot to show you guys my fancy thing here. Yeah, you guys see it already though. Yep, I keep it with me when I'm rolling, when I'm streaming.